Good morning. We're going to talk about Social Security disability benefits today. My name is Fay Fishman. I've been practicing in this area for well over 30 years. More than that, I won't admit to. I do this presentation on a regular basis. I usually do it to a full audience instead of looking at myself on the screen, which is very weird. But we're going to get through this. This is new for me and Social Security is new for you. So together we're going to get through it. So I was asked today to just give an overview on Social Security disability benefits and SSI benefits. So that's what we're going to do. It's really just an overview. It's not in depth on any part of the presentation. Always happy to answer any questions that you may have. So following the presentation or at any time, if you have questions, just feel free to give me a call. I'd be happy to answer. So our topic today is Social Security disability benefits, and Social Security defines disability as, and this is a mouthful, I have to take a deep breath to get through this, the inability to engage in substantial gainful activity by reason of any medical determinable impairment, physical or mental, which can be expected to last for 12 months or result in death. Wow. So to meet this definition, you have to have a severe impairment that makes you unable to do your past work or any other work that exists in the economy. And all these terms throughout the definition are really defined as we enter into the system that Social Security uses to determine whether or not you're disabled. So we're just going to jump right in to this. And I'm a fast talker. I'm trying to slow it down. But anything that I tell you, you're going to have in your materials. So relax, listen, and then you can look it up in the materials or you can give me a call. So Social Security uses a 5-step sequential evaluation process in determining whether or not you're disabled. And sequential is important because we start at question 1 and we go to question 5. If at any time we get a definitive answer, we stop the process. So question number 1 is the claimant, and that's you, engaging in substantial gainful activity, which we call SGA. And SGA is a set amount that's determined by Social Security annually, so it changes every year. And essentially, if you are working and your gross earnings are more than this amount, Social Security will stop the evaluation process at that point and will not even look at your disability. So we look at, are you engaging in SGA? And SGA currently, if you are blind, it's $2,100. If you have low vision but are not blind, it's $1,200. So you can see there's a huge difference between blind and low vision in Social Security determining substantial gainful activity. So we have to go further though, because we don't just look at your gross earnings to determine if you are engaging in SGA, because sometimes your employer, for one reason or another, really likes you and pays you more than you're worth. I had a gentleman who was a quadriplegic who worked for the Minneapolis Star and Tribune for many, many years, got in an accident, became a quadriplegic. His employer kept him on at full value, at full salary. So even though he did very little work, came in when he wanted to, and was just really the cheerleader around the plant, they paid him his full salary. So every year we fight Social Security on this because they look at his earnings and they say you're earning SGA. But in reality is he's not, because we look at different things in determining whether your work activity is substantial gainful activity or not. So if you receive special accommodations from your employer, we reduce your earnings by the amount of the accommodations. So if you're only really earning 50% of your salary, we look at that 50%. We don't look at the 100% salary. So if you get any kind of subsidies in employment, you get special duties, you work less hours, you can take breaks whenever you need it. We have a form we send to your employer that just determines how much of your work you're actually doing versus what you're getting paid for. And that's what the number we look at when we determine substantial gainful activity. We also look at impairment-related work expenses or blind work expenses, and they're essentially the same with a few differences. So I'm just going to talk generally. If in order to work, you have to have special items that you have purchased out of your pocket that allow you to work, we deduct that dollar for dollar from your earnings. Transportation that you might need to get to work is deducted downward. Any special accommodations you need because of your vision. Medicines, anything you pay out of your own pocket, we reduce dollar for dollar. Now, oddly, we can't reduce insurance premiums but we can reduce with co-pays. So we look at all these factors when we determine whether the work activity you're currently doing is substantial gainful activity. If you are not engaging in substantial gainful activity after we look at all these factors, then the next thing we do is we look to see if you have a severe impairment. So if you are engaging in SGA, inquiry is over. If you're not engaging in SGA, we go to step number 2, is do you have a severe impairment? And in order for there to be a severe impairment, it must be medically determinable, and it must meet a 12-month durational requirement. So medically determinable means that it's not just based on your complaints alone. So headaches become very difficult if it's just headaches alone. But any vision issues through vision testing become medically determinable. So, and then the impairment has to look like it's going to last 12 months. And that means that from the time that you are unable to work until you may be re-able to work has to be 12 months or you don't meet the requirement. It doesn't mean you have to wait 12 months to apply. It just has to look like it's going to. So as we look in the crystal ball, if it looks like it's going to last 12 months, then you'll meet step 2. We lose very few cases at step 2. So if you have a severe impairment, the next thing we look at is, do you have an impairment that meets or equals a listing? Social Security has so many different terms that are difficult to understand, but the concepts are really simple. And what a listing is it's categories of impairments. And if you have a disability that falls squarely within one of these categories of impairments, Social Security will find you're disabled. It's pretty simple, okay? There are 3 different blind listings. One is that the remaining vision in your best eye is 20/200 after best correction. So we don't look at you uncorrected, we look at you in your best correction. We really only look at one eye. And if in that one eye you have 20/200 vision or less, you will have met the listing. The other listings look at the field of vision and loss of visual efficiency. The materials you have a link to the listing so you can read them in specificity. But this is generally, if you meet the definition of legal blindness, you will meet Social Security's definition of disability, okay? If you are not blind under this requirement, but you have low vision, then we skip this step because there is no listing for low vision. It's only for actual blindness that we have a listing. But there are other ways to get disability, so we don't worry about that. In fact, very few cases of disability are won on a listings. Most of them go through the full evaluation process. So if a listing is met or equal, disability is awarded. If it's not, we go on to question number 4, and that is, can you perform your past relevant work? Past work is defined as work done in the last 15 years prior to the onset of your disability. So once we have your jobs, then we break it down by categories. Physical requirements, non-exertional requirements, and cognitive requirements. Again, you know, Social Security uses all these big words, but they're really for very simple concepts. And we look at, can you do your past work? But here's how we evaluate it. There are different categories of physical impairments. So there's sedentary, which involves lifting of no more than 10 pounds and sitting 6 hours of an 8-hour day. Light, which you lift 20 pounds occasionally, 10 pounds frequently, and you have the ability to stand, sit, or walk 6 hours of the day. Medium, you're lifting 50 pounds frequently, 50 pounds occasionally, 25 pounds frequently with unlimited standing, sitting, or walking, and then there's heavy work. We also look at the non-exertional requirements of your job. That's the needs of your job to have you be able to kneel, squat, crawl, climb, reach, and other things that aren't quantifiable in terms of pounds or hours, but are attendant to jobs. You have to be able to see. For a low vision case, we look at how your impairment impacts your ability to see. And again, we're categorizing your past job. So if you have a job as a computer tech, the ability to see is 100% of your job. If you have, if you are a elevator operator, which really doesn't exist anymore, it is a much less requirement of the ability to see. So then we look at the skills that were part of your past job. Was your past job unskilled? Very little training. You didn't need to use a lot of judgment, and it's 1 or 2 or 3 steps. Semi-skilled, which you have to do some learning on the job. It's alertness, machine tending. It takes up to about 3 months to learn the job. And then there's skill work, which requires the use of judgment, maybe dealing with people, facts or figures, abstract ideas, that type of thing. So we look at your past job, we put it into one of these categories: light, sedentary, heavy, skilled, unskilled. We put it into one of these categories, and then we determine if you have the functional capacity to return to the job. Again, another big term. RFC stands for residual functional capacity. And that now, instead of looking at the job, we shift our focus to you. So do you have the physical capacity now to do the jobs that you've done in the last 15 years? Okay. And we look at this as what you can do despite your impairment and with your best correction. So taking your medications, wearing your glasses. So what are you able to do when you have your best correction, or you're in your best condition with the condition that you have now? So we try to match up your past work with your residual functional capacity. And if you have the functional capacity to do your past work, the inquiry ends and you're found not disabled. But if you can't match those up anymore, then we go to step 5, which is there other work you can do in light of your age, education, transferable skills, and residual functional capacity? So we look at the age category first, and Social Security has these lovely age categories. You're younger if you're under age 50. You're closely approaching advanced age if you're 50 to 54. You're of advanced age if you're 55 or older, and that's lovely. I'm of an advanced age. And then, or are you closely approaching retirement age, which is age 60 or older? And as you advance on each of these categories, the standard for disability becomes easier. We look at something called, well, I'm getting ahead of myself. We then look at your education. Are you illiterate? Do you have a high school education, or do you have more than a high school education? Under illiterate, we used to have the inability to speak English. And it's probably still there, although it's just in the process of being eliminated, so I did not include that in here. One of the issues was that there's a lot of people who speak different languages in the United States now who are fully capable of working. When these were written so long ago, that was very, very uncommon. So we eliminated that, and now we just have illiterate, high school, or more than high school. And then we perform a transferable skills analysis. What skills did you have from your past job that we can take and translate into other work that you can do? If you were an office clerk, you have skills such as filing, organizing, keyboarding, that type of thing. If you had an unskilled job, you don't have any transferable work skills. So the more skills you have, we look at how they translate into other work. Skills that you might have had from medium work are not necessarily going to translate into sedentary work. If you are a machine tender who now has to have a job sitting down, you might not be able to take those skills from machine tender and go into other jobs. So once we have your age, education, and transferable skills figured out, we then go to a grid system, which we call Appendix 2 on the Social Security regulations, and it's a grid. Over here we have whether you can do sedentary, light, or heavy work, and on top we have your education and your skill level that you can do, and where the two meet, it says disabled or not disabled. Unfortunately, we use this in very few cases, because if you have any impairment other than just the ability to stand, sit, lift, and carry, we can't use the grids because they don't factor in the ability to see, the inability to reach, the need to crawl or squat. So that only works if you have just limitations to stand, sit, lift, and carry. Otherwise, we use a vocational expert or vocational evaluator who will take your present set of skills and determine whether there's work that it can be done at step 5 of the evaluation process. So you can't do your past work and you can't do your other work, you're now considered disabled by Social Security. Whew. That's a long way of getting to you're disabled if you can't do your work or you can't do other work that exists in the economy. So there are some special blindness rules that apply. And again, these only apply to blindness. They don't apply to low vision, okay? So the substantial gainful activity is higher if you are blind than non-blind. There are special rules that apply to age 55 that I'm really not going to go into because honestly, I'm not sure I understand them and they really don't have a whole lot of applicability in the real world, but let's just say that they're there. If you have an SSI claim and instead of a disability claim or along with a disability claim, you don't have to meet that 12-month durational requirement to get SSI if you're blind. And then we have special rules to determine whether or not you're engaged in SGA if you are self-employed. And they're very complicated and I'm not going to go into those today. Low vision claims are evaluated as all other disability claims are. And we do very few blind cases because either you meet the listing or you don't, but we do a lot of low vision. There's a lot of things that accompany low vision. And so we look at not only your visual acuity and your peripheral vision and how your actual vision is, but we look at everything that goes along with it. We look at headaches, we look at eye strain, we look at the fatigue that goes with it. A lot of people experience nausea from their low vision or disorientation or dizziness. So in a low vision claim, we analyze all those factors that go into determining whether or not you have ability to work. And on that vein, it is so important. Every time you see your doctor, you describe the symptoms that you have. So when you see your eye doctor, you're not just going to talk about your vision. I want you to talk about the nausea or the headache or the fatigue. And when you go to visit your regular doctor for your annual exams, I want you to talk about this stuff. So when Social Security is gathering your medical records and they're looking at your claim, they see that you have all these problems and they're not appearing in your application for the first time in your Social Security paperwork. Really, really, really important that you do this. And if you're not the type that can complain or report, not complain, if you're not the type that can report, then I want you to take someone with you. I want you to take a spouse or a friend or a parent, because it's vital that your records show that you're having these problems. And so it has to get in your records, not just at one visit, but I'd like them in your records at every single visit. So along that line, I'm getting ahead of myself here, but along that line is when you are thinking that it's time to file a disability claim, I don't want you to go from 0 to 100 all at once. I want you to build up to this. Make sure your records talk about how difficult it is for you to continue your work, that you're trying, you're doing everything you can, you're using all the accommodations that are available to you, and you still can't do it. You leave work with headaches and with nausea and dizziness. You're tired all the time, and you just don't know that you can continue to do it. So if your medical records are building up to the disability, when it's time to file for disability, it's going to be much easier for you. And that leads us to our next area we're going to talk about is how to get benefits. So the materials you have talk about the application processes. You can file your application online at ssa.gov, socialsecurityadministration.gov. There's lots of other ways to get to the Social Security website, Social Security Online, socialsecurity.gov. Always try to remember to use ssa.gov. There are a lot of attorneys who want you to hire them on their disability claim, and their website is one keystroke away from all the other ways of getting benefits, and you don't have that issue if you go to ssa.gov. So you can go to ssa.gov, you're going to just follow the links that say disability. You'll have to create a Social Security account, and it's going to take you to the application. The application, you're going to need the exact date that you stopped working, and you're going to need, at some point in the application process, you're going to have a work history form you have to complete. You'll have to complete a form giving the names and addresses of all your doctors. That's really it in a nutshell for what you need to prepare in order to file your application. It's a very simple process. We follow the keep it simple, stupid rule. Anytime you do anything in a Social Security form, you're not going to go on and on and on and talk about all your disability problems, because hopefully your medical records are going to do that for you. So you're going to file your application, which lists the date that you became disabled. You're going to do the work history form that asks about your work history for the last 15 years. You're going to do the form that asks about the names and addresses of your doctors, and that's all you need to do to file your application. If you're approved, wonderful. If you are not approved, then you have 60 days to file the first appeal, which is called reconsideration. And reconsideration is just a form that you fill out called request for reconsideration that asks why you're appealing. And again, we follow the keep it simple, stupid rule, and we just say we're appealing because we're disabled and we can't work. It's a one-page form, very simple. You'll have a questionnaire to fill out about your daily activities and about the medical sources you've seen, not from the beginning like you did the first time, but just since you filed your application. So it's a much simpler form. We recommend that you keep copies of what you do, and you can do this online. You just go back to the Social Security website, you click on disability, and then there's a link to appealing an unfavorable decision. Reconsideration, very few people get paid at reconsideration. So most likely if you are denied on your application, you're going to be denied on reconsideration. Every once in a while, Social Security screws up and actually pays someone, so you might be one of the lucky ones. But expect to be denied if you are denied on your application. So the next step is a hearing in front of an administrative law judge. In the pre-COVID era, you would go in person to a hearing in front of a judge, and you would talk about your problems. In the current era, with COVID, Social Security offices are closed, district offices are closed, hearings offices are closed. And so you have one of two choices. You can do a telephone hearing, or you can do a postpone until you can get a live hearing. Right now, we don't know when live hearings are going to be held. So there's good sides and bad sides for both. So we encourage you to talk to someone before you make that decision. But generally, hearings are running a year to a year and a half from the time that you apply for your hearing. Hearings last about an hour or less. You go in, you want an attorney for this stage. You go in with your attorney, the judge will ask a series of questions about your day-to-day life with your disability, nothing you have to prepare for, nothing you have to study. It's more of a conversation. It's not like any court you've seen on TV. There's no one cross-examining you. Social Security does not have an attorney in the process. So you go in and you tell your story. The Social Security judge may have a doctor or a vocational person there to testify also. Like I say, hearings last about an hour. You get either a favorable decision or an unfavorable decision following the hearing. And there are many further appeals after the hearing. There's always an issue of whether or not to hire an attorney when you do an application. I feel very, very strongly that you do not hire an attorney while you do your initial application. No matter what all those ads you see on TV are telling you, attorneys do not do anything for you on your initial application except to provide you with a very well-paid secretary, because it's all factual. It's based on you, it's based on your job history, it's based on the names and addresses of your doctors. So get someone to help you type it and you'll get the same services you get from an attorney at that stage. And the same is true for reconsideration. Really, it's at the hearing that you absolutely want to have an attorney. Now, I'm not saying don't talk to an attorney when you're going to do your application or when you're going to do reconsideration. My office and a lot of other offices are more than happy to talk to you about the application process and reconsideration. In fact, if you're denied, I want to hear from you because I want to make sure you're going to do the reconsideration. More people are denied than are approved, and it's very demoralizing. But we want you to know that you're not alone, and you just have to go through the process. You have to play Social Security's games at their rules, and ultimately you can be successful in your application if you do that. So talk to an attorney. Don't necessarily hire an attorney when you start your application process, but talk to an attorney. Just talk about your particular situation so they know if there's anything special that needs to be addressed or anything special that needs to be done. You absolutely want an attorney to go into the hearing with you, vital. So make sure that you have an attorney at that point, and don't wait till the last minute to hire someone. As soon as you're denied at reconsideration, make sure you start your process of hiring an attorney. How you choose an attorney is a difficult question to answer. I get asked that all the time. You know, it's like you're going to choose a doctor who's going to do surgery on you. You don't want the doctor that's only done the surgery 1 or 2 times, but you don't want the doctor that runs a mill and does 1,000 of them a year. You want the middle ground somewhere. You want someone who's going to know your name when you call and will give you personalized attention. So ask questions when you hire your attorney. And make sure you get someone who you are comfortable working with. Follow your gut. So attorney's fees in Social Security cases are set by federal law, and it is 25% of your back accrued benefits, and we'll talk about back benefits in a little bit, with a cap at $6,000, and that cap can change, but it's been at $6,000 for a long time, and I don't see anything right now happening to change it. And that's on a contingency basis. If you're not successful, then you don't pay your attorney. So we have the two different benefit programs that I'm going to talk to you about today. One is SSI and one is disability. So SSI, which stands for Supplemental Security Income, is a needs-based program. It has the same requirements for meeting medical standards as all other programs, but it's needs-based. So you have to have very little assets and income. And the benefit that you receive is a monthly cash payment and Medicaid. The other program that we're going to talk about is Social Security Disability. It's called Disability, SSDI, RSDI. There's lots of different names, but this is the insurance program. So in every paycheck you get, they take out FICA. Well, the FICA not only buys you retirement insurance, but it buys you disability insurance. But there's a fundamental difference between retirement and disability. In retirement, once you have paid the minimum amount into the system, you are insured forever and you will get your retirement benefit. On disability benefits, though, not only have you had to pay the requisite amount in, but it must be done during a relevant period of time. And again, the materials go into this a little more. It's not something that you need to know, except you need to know that it exists. The benefits you get are cash benefits and Medicare versus SSI, it was Medicaid. In disability, it's Medicare. And under disability, your minor children may be entitled to a benefit also, and that doesn't happen in SSI benefits. So that's it in a nutshell on disability benefits. I hope I provided you with enough information for you to understand the programs. It's not as complicated as it seems. I want to leave you with a thought, though, is if you ever have to call the Social Security office, I want you to treat it like the IRS. I want you to call 5 times and average your answers. I'm joking, obviously, but the Social Security Administration is not the best source of answers for your Social Security questions. Most attorneys who do this are not doing this to make millions of dollars. We do this because we care about disabled people and are more than happy to talk to you. So feel free to contact a disability attorney. If you're calling the first one and they won't talk to you, call another one, because there are a lot of good attorneys out there. So this ends my presentation. I hope you got something out of it. This was a new experience for me. And I wish you all the best, and thank you.